My name is Mark Nordenberg. I'm a former chancellor of the university, a former dean of this law school, and currently have the privilege of serving both as the chair of Pitt's Institute of Politics and director of its Dick Thornburgh Forum for Law and Public Policy. Through the programs supported by the Dick Thornburgh Forum, we aim, among other things, to extend the impact of his legacy. Dick had an absolutely amazing career. United States Attorney for the Western District here, Assistant U.S. Attorney General in charge of the Criminal Division, two-term Governor of Pennsylvania, United States Attorney General under both President Reagan and President George Herbert Walker Bush, and Undersecretary General of the United Nations. And as impressive as that list is, what is far more important than the number of roles he played is the good that he did from each and every one of those positions. It also is important to remember that Dick Thornburgh was a very proud graduate of this law school. So for students who are with us today, if you want a role model, if you want to know what the heights to which you can climb with a Pitt Law degree, look at Dick Thornburgh and what he did. It's a very inspiring record. I do want to acknowledge the presence of Ginny Thornburgh, Dick's widow and the former First Lady of Pennsylvania, by far the most important member of the Thornburgh Forum team. Two of the sons of Dick and Ginny, John and David, are joining us by live stream, so they are with us more than in spirit, even though they're not in the room. And I want to acknowledge both Samantha Balbier, who is the director of the Institute of Politics, and Beth Schwank, who is the executive director of Pitt Cyber, the organization that is co-sponsoring today's program with us. I'd also like to thank and acknowledge someone who has been at many past Thornburgh Forum programs, but is here in a different role today, and that is Jerry Dickinson, who is celebrating the 8th day of his service as he was appointed Dean of the Law School 8 days ago. Jerry has long been a member of the law faculty. He has long been an important member of the law school's leadership team. So we know him, we like him, we respect him. And most important, Jerry, and I know that when I say this, I speak for everyone who cares about the law school, we want to help him. So don't be afraid to reach out and ask for a boost when any of us can give it to you. I also want to acknowledge the partner on the right-hand side, Mary Crossley, who served as dean of the law school for many years and who stepped back into the breach on an interim basis and probably was happy to pass the baton to Jerry 8 days ago. Mary, among other things, delivered one of our most recent Thornburgh family lectures on disability law and policy, and having attended most of them over the course of the last couple of decades, I would say that it was one of the most thought-provoking presentations we've had. So I thank you too. Now, I first began building a relationship with Dave Hickton in this very room. He was a young law student. I was a young faculty member. He was a member of an all-star national moot court team and occasionally accepted a little bit of advice from me. So we got to know each other here and in my advanced civil procedure class. And for the last 40 plus years, not only have we remained friends, but we have built a friendship that has grown stronger with each and every year as we have partnered together on things. Dave is the former United States Attorney for the Western District of Pennsylvania. He is the founding director of the Pitt Institute on Cyber Law, Policy, and Security. And as I mentioned, Pitt Cyber is our co-sponsor of this program today. And I probably should confess that Dave and I seize every opportunity that we can to partner on anything. And this may seem strange, but to give you some sense of how strongly I feel about Dave, his investiture as the United States Attorney is an event that I consider to be one of the most memorable experiences of my professional career. And I say that because he spoke about the values that were going to help him set priorities and otherwise lead the office. And I thought if everyone involved in federal law enforcement could have those values on a sheet of paper in their pocket or something, we all would be better off. And I only hope that those values have not completely gone out of style in 2025. Dick Thornburgh believed in the rule of law. He believed in America's legal system. He believed in the pursuit and acceptance of facts, as is reflected in his autobiography titled Wherever the Evidence Leads. Dave Hickton, Chuck Rosenberg, and I think I can safely say, are all disciples of Dick Thornburgh when it comes to such values. And Dave and Chuck can speak for themselves and will later. But as much as I love the legal system, I am worried about some of the pressures that are being applied to it these days. And as I thought about those concerns that I know are broadly shared, I also thought that there was no one who would be a better person to share perspectives than Chuck Rosenberg. After working his way up, Chuck held positions at the highest levels of the Department of Justice, the FBI. He was the acting head of the Drug Enforcement Agency. He served as United States Attorney in two different judicial districts, two different districts and two very different districts, the Eastern District of Virginia and the Southern District of Texas. He is a nationally respected legal analyst and the founder of an award-winning podcast, The Oath. Whenever I see that Chuck is going to be on television, I try to catch him because I know that he is going to provide very reasoned perspectives on whatever issues are brought his way. He is a person who provides more light than heat, and we probably could use more of that today. Chuck is a great friend of the Thornburgh family and of the Thornburgh Forum. I think this is the third program that he has done for us. In addition to this program, he met with law students this morning. He's meeting with honors college students tomorrow. And last evening, when Dave, and I got together for a planning dinner, He was called to perform another service for this community that was totally unanticipated. Someone else in the restaurant had a heart attack and fell over on the floor. And very quickly, Chuck and a couple of other patrons were taking turns providing CPR during what seemed to Dave and me to be an incredibly long period of time before the emergency professionals were there. The man had lost his pulse. They brought him back to life. And today he apparently is doing well. So let me give you our friend, teacher, and lifesaver, Chuck Rosenberg, and our friend, model prosecutor, and Professor Dave Hickton for a discussion of the federal law enforcement system and some of the pressures it's facing today.
Thank you, Mark. Let me begin by thanking all of you for attending, and thank you, Chuck, for coming back to Pitt and for our long friendship and all of our partnership over the years. We're in interesting times, and depending on your perspective, they're fearful times or hopeful times. But I'd like to begin with a discussion about the rule of law.
Sure.
What is the rule of law? What does it mean? What hope does it give us? And can it smooth out the seemingly turbulent waters we're in today?
It should give us hope. It's something we have adhered to for a very long time. But I always describe it as a construct, meaning it's not immutable. The law of gravity is immutable. The law of gravity exists everywhere all the time. Right? If I drop this cup in a failed state like Syria, it's still going to hit the ground. But the rule of law depends on all of us, the hopeful, the fearful, and everyone else, to ensure that it survives. And I think it's always at risk. I don't think it's uniquely at risk now. I think it's always at risk. And if you look at the arc of American history, from the Trail of Tears to the Civil War, to the rise of the KKK, to the internment of Japanese Americans in World War II, there have always been threats to it. That's not new. It's on us to protect it, David.
We talk also a lot about equal justice under law, and the aspiration that justice is blind and that we can trust that the justice system will somehow work its way to the right result. Are we all equal under the law, or are some of us more equal?
We are mostly all equal under the law. But I think I know what you're getting at. And presidents, and I don't mean Trump or Biden or Clinton or Bush or Millard Fillmore, presidents are different, right? And so when we talk about the rule of law, we also often say no man is above the law, no woman is above the law. And that's not entirely true for at least 4 reasons I can think of, right? I mean, a president, again, any president, has an executive privilege, which none of us enjoy, putting certain conversations off limits. Presidents have pardon powers, which are extraordinary and could be used, well or poorly, and have been used in both ways over the, life of our country. Presidents have immunity, and we can talk more about that if you want, David. And there's also a Department of Justice policy, actually iterated twice, once during the Nixon administration and once during the Clinton administration, saying that sitting presidents can't be charged with a crime. So, for at least those 4 reasons, and a lot of smart people here could probably think of others, presidents are a little bit different.
I think I'd like to go through each one of those 4 that you described.
Okay.
What have been tension points or flex points on executive privilege, And what do those experiences tell us about where
Sure.
we may go next?
So first, know that every president of the United States, starting with George Washington, has invoked executive privilege, all right? A privilege not to turn over certain documents or communications, typically to Congress. They want more, presidents want to give less, and so this is not new. But it does put off limits certain conversations that a president has. And so this is an ongoing battle. The courts tend to stay out of it. Usually they hope that Congress and the executive resolve it in some way, and usually they do. That's a norm. It may be a fading norm, but it has been a problem. I shouldn't say a problem, David. It's been an issue since our founding.
Mm-hmm. What about, we talk about pardons, but pardons are really pardons, clemency, commutations. Where does that power flow from?
Yeah.
And how has it been used and maybe expanded and misused recently?
Yeah, so it flows from Article 2 of the Constitution, and it's a plenary power of any president, just as when Dick Thornburgh was governor of the Commonwealth of Pennsylvania, he had pardon authority over state crimes. A president has pardon, clemency, commutation authority over federal crimes. And again, our experience with it as a nation has been spotty. I can think of awful pardons from, presidents I admire, like George H.W. Bush. Awful pardons from Bill Clinton during his 2 terms in office. I think most recently, head-scratching pardons, to put it kindly, from Joe Biden. And you're probably thinking of the pardons, the 1,600 or so pardons of the January 6th insurrectionists, also deeply troubling.
I looked online. George Washington was president for 8 years and issued 16 pardons.
Well, there were a lot fewer people back then.
For context, during the Civil War, Abraham Lincoln issued less than 500 pardons.
Yeah.
Gerald Ford is the author of perhaps the most famous pardon, Richard Nixon,
Right.
and issued less than 500 pardons.
And Jimmy Carter pardoned a large number of Vietnam War draft evaders.
Correct.
Yeah.
And Joe Biden, between pardons, commutations, and clemency, the number is 8,064.
Yeah, I mean, right, there's a trend, sure.
Is that good for us?
I don't know. So here's how I think of pardons, and then when I worked at Maine Justice, was a small part of the pardon process. I mean, at least traditionally, a pardon, right, was an act of mercy. Somebody had committed a crime, they had gone to jail, they had served their time, they got out, they were integrated back in the community, they are remorseful, they've paid their debts, they're now working, they're paying taxes, they're perhaps supporting a family, they've demonstrated contrition, and so over a long period of time, it's something that they have sought and received because they've earned it. And I think if we get away from that model, regardless of who the president is, David, I think that's problematic.
And it's not entirely clear as a legal matter that you actually have to admit guilt to receive a pardon, is it?
Well, yes and no. So, all right, Dean, you'll appreciate this. I'm going to get legal nerdy. There is a 1913, 13 or 15, Supreme Court case called Burdick. And it stands for the proposition that if you accept a plea of guilty, a pardon, if you accept a pardon, then there's an imputation of guilt. Really interesting side story. Ford, as you know, drew a lot of heat for pardoning Nixon. And to his last day on this earth, Gerald Ford kept an excerpt from the Burdick case in his wallet that a pardon, the acceptance of a pardon, implies an acknowledgement of guilt.
Let's turn to immunity. We had a very significant decision out of the U.S. Supreme Court in July.
You did.
Following a battle that went on for months. What is the state of play with regard to immunity, and how did we get to where we are today?
So it's more confused. But can I back up a little bit?
Sure.
So there's an interesting backdrop to this. The Supreme Court said in the Trump case that there is implicit in the Constitution immunity for a sitting president. Again, any president, Republican, Democrat, doesn't matter. But think about this scenario. There's a statute in Title 18 of the United States Code, the Criminal Code. I think it's 2383. Jimmy Kitchen would know. The foreign murder statute.
The great Jimmy Kitchen.
The great Jimmy Kitchen. The foreign murder statute. And it's really simple. If a U.S. person kills another U.S. person abroad, that's a federal crime. So in 2011, and this is not a stretch, Barack Obama, President Obama, ordered the targeted killing of a U.S. citizen named Anwar al-Awlaki, who had joined al-Qaeda. And they ran all the traps through the Office of Legal Counsel and all the advisors to the president, and Obama ordered that the strike be made, and al-Awlaki was killed. To our knowledge, the first targeted killing ever of a U.S. person by a president. However you feel about targeted killings, however you feel about drones, put that aside. That's what happened. Technically, it's violative of the foreign murder statute. A U.S. person, Obama, ordered, created the circumstances for the killing of another U.S. person, al-Awlaki, abroad in Yemen. There you go. Should a president be immune, again, putting aside how you feel about targeted killings, should a president be immune from criminal prosecution for making a sort of a paradigmatic Article II commander-in-chief decision? And I think the answer is absolutely yes. So there has to be some sort of immunity for a president when he or she is acting within their core constitutional responsibilities. The Supreme Court said that. They also said a lot of other stuff that makes absolutely no sense to me, and I think remarkably complicates a prosecution of any president in many different ways, which we don't have time to get into here. But a president has always implicitly been immune. That's what Obama's legal advisors told him in 2011 when they took the shot. And now a president is explicitly immune because the Supreme Court has said so.
Well, and these immunity discussions aren't just at the presidential level. In the room, we have Eric Olshan, recently U.S. Attorney. We have
who led the prosecution for the Tree of Life synagogue. Yeah.
We have Fred Tiemann, a former U.S. Attorney. We have some DOJ all-stars, Sharon Werner, Steve Kaufman, the great Jimmy Kitchen.
Don't forget Rebecca
Haywood. Yeah. All of us who were making decisions about whether to prosecute or not prosecute a case, particularly in this environment of retribution, had the right to understand that our decisions were respected and that immunity applied for our decisions, didn't we? As the debate was going on about Trump's immunity, I was rooting for an immunity decision.
You got one.
But the question is, have we created a king? Do we have a president or a king now? Because if the only way to deal with a president, given DOJ policy and the need to impeach while he's in office, or she is in office, doesn't that allow a president to commit crimes? Wasn't Justice Sotomayor in her dissent correct that a president running for re-election could kill his opponent under that decision?
I don't think she's right about that. I think for core constitutional responsibilities of a president, yes, there is some ill-defined remainder of things that a president can do that would not be immune and would violate the law. I mean, and we can create hypotheticals. But is a president a king or a president? I mean, so some of you who will be old enough like me to remember a candy called Razzles. And the commercial, is it a gum or a candy? And no, who the hell knew? I've had it, not for many years, but I never could answer that question. A president is a little bit of both, just as a president is a little bit astride the law. because of those things we talked about, David. A president is a little bit of both. And that doesn't sit well because, in our, Republican form of government, we think that no person is above the law and that a president is not a king. And I think that's an oversimplification.
What is the way we go about investigating presidential misconduct?
It's very hard now.
What is the process and what can we expect?
Yeah, and again, this is for any president. This has nothing to do with Trump or Biden. This is for anybody who holds the office. The Supreme Court has put certain things just off limits, which strikes me as nuts, which is my technical legal interpretation. So, a conversation between a president and her Justice Department is off limits, even if she's telling the Justice Department to do things that are corrupt, to open investigations of people for political gain. You can imagine a million different ways that it could be corrupted. The Supreme Court has said that's off limits. How can that be right? That's a rhetorical question. The answer is it's become much, much more difficult.
Well, we've gone through for the last 30 years this whole special counsel process. How has that served us?
Not well. So if you get, I'm sorry, a little history. So if you think back to Watergate, we had a special prosecutor. His name was Archibald Cox. And when Cox was fired, Leon Jaworski became the special prosecutor. And there was a sense that special prosecutors who could be fired by the president didn't have enough independence. So we needed to create something completely different if you were going to investigate the president. So we created the aptly named independent counsel. And that didn't go so well, right? Some people will say Ken Starr went off on a frolic and detour as independent counsel. And independent counsel were outside of the Department of Justice. They answered to a panel of 3 federal judges. And whatever you think of Starr and whatever you think of his investigation, Congress thought that when the statute lapsed in 1999, it should not be renewed. And we end up with this special counsel thing, which is really a set of internal regulations. And I think it's flawed for a whole bunch of reasons. I hate the notion, so the great Jimmy Kitchen knows this. Eric knows this. When as federal prosecutors we decline charges, we walk away. We're done. We say nothing. We want to, investigate Mark Nordenberg. We do. Turns out miraculously that he's clean, David. And we walk away. And that's what we should do. And if we have something to say about Mark, we say it in open court. And then we got to prove it to a jury of his peers by proof beyond a reasonable doubt and unanimously so. That's our burden. But if we're not charging him, we say nothing. Remember, special counsels are required by the regulation to write a report outlining all of their theories of the case, their reasons for declining, or whatever it is they do. And you get these big reports. You get them from John Durham, you get them from Bob Mueller, you get them from Rob Hur. We may well get it from, we got one from Jack Smith, right? Was that been released?
He just filed one, yes.
Yeah, one's been
Part
released,
of it's hung up in the court.
And I just hate the notion that prosecutors write reports for public consumption when they're declining charges.
But they haven't had to prove anything.
They haven't proven anything. So I can write a whole bunch of things about Mark Nordenberg in my report that I'm not going to charge him with and I can't prove. But how does he respond to that? The other thing I hate about special counsels, people who serve as special counsel, is that you're singularly focused. So Eric ran a big, important U.S. Attorney's office. So did you. So did Fred, here in the Western District of Pennsylvania. His assistants have dozens of cases, perhaps scores of cases. They don't focus on any one person or any one thing, right, uniquely. But a special counsel does. And I just don't think that's a good model for federal prosecution.
If Jack Smith had decided to bring charges, he still had to take that to Merrick Garland. How does that work?
So Ken Starr was an independent counsel. Jack Smith and John Durham and Bob Mueller were special counsels. They were not independent. The way the regulations are written, an attorney general does not have day-to-day supervision, but has the ultimate decision. So, so you put your finger on another huge problem, David. We have set up ostensibly a quasi-independent prosecutorial office that is actually tethered to the Attorney General of the United States. There's a lot of problems there. And maybe the answer is, and again, this has nothing to do with Trump or Biden or any particular president, it's just really hard to investigate a president because the president controls the executive branch. And whether it's a special counsel or an independent counsel, that person is in the executive branch. And now you layer on top of that the immunity decision.
One of the most amazing things about my experience at the Department of Justice is I began to appreciate that on a continuum, there were laws, there were conventions, there were personalities.
Yeah, there were.
And there was trust and restraint by people in the system who trusted decision makers like we trust referees in sports.
Yeah.
So to illustrate this for those who were not there, some from the DOJ would know, let's talk about the late, great David Margolis.
Okay.
Tell everybody who David was and how he operated, because I dealt with him, you dealt with him, Fred dealt with him.
Yeah, David Margolis, for those of you who don't know him, was essentially Yoda with a Harvard law degree. He was this, he looked like he not only slept in his clothes, he looked like he hadn't changed them in 70 years. I love his past. I love that man. He was a mentor to me. He was a friend to me. We shared Washington National season tickets through some pretty rough seasons, which Pirates fans will know well. But he was sort of the conscience of the Department of Justice. He was the senior most career official, meaning that if any attorney, and he served them all. I mean, Republicans, Democrats, didn't matter at all to David. Called him like he saw it, got some things right, got some things wrong. People argued with him all the time. His office looked like a dumpster fire would be complimentary. But he had this reserve of knowledge, and you could go to him and get his honest opinion. And he might be wrong sometimes. That's okay. We're all human. We're all fallible. We're all wrong on occasion. But he was there for the entire department. And every attorney general kept him there.
From the 60s, basically.
I think from the 30s, for God's sakes. And there were other people like that, too. Jack Keeney in the criminal division. Jack Keeney died at the age of 94 or 95. Retired from the department just a year earlier. I mean, there were this font of wisdom and knowledge. And I know some people derisively, David, call it the deep state. It's not. That's not what it is. It's sort of the heartbeat of that institution. And that's how you learn as a new person, and how the culture and the rules and the norms get passed down.
Right. But some of the people in the room were at my elbow when I, as a politically appointed U.S. attorney, had to wrestle and struggle with career people who basically felt that they could wait me out.
They could.
And if I decided something was important and we were going to do it, they could say, well, he'll be gone in a little while, and we don't have to follow that. So I guess the question is through administrative policy and to make elections matter, what is the line that we're looking for? Does the president get to pick people?
Yes.
But not interfere in the cases?
Hopefully.
Does the president get to set policy?
Yes.
So how far are we today from the norms when you joined the Department of Justice in 1990?
So, I mean, you have to be careful about using the word norms as synonymous with good. You can have good norms and you can have bad norms.
Right.
And some norms ought to disappear and some ought to survive. So, it looks different. It feels different. I'm worried because the more that the good norms erode, the more the rule of law is threatened, right? I mean, that just seems obvious. I was going to say axiomatic, but I don't know what axiomatic means. So I'll just say obvious. But a president is the head of the executive branch, and the Justice Department is indisputably within the executive branch. And so there are lots of places where it's completely appropriate for a president to, do things that are political, to appoint judges, to set policy. I mean, one president wants to focus on Project Safe Childhood, and another president or attorney general wants to focus on Project Safe Neighborhood, and another president wants to, stand up a bank fraud task force. That's fine. But there are other norms that I think should be sacrosanct. For instance, you mentioned whether a president can or should interfere in investigations. That's a hard one, because you think the simple answer is, no, absolutely not. No president could ever interfere. Well, what about national security investigations? What about espionage investigations? What about investigations that might involve the diplomat from another country, right? What about when a president has to take military action based on the fruits of a criminal investigation? So we say, well, we never talk to a president about investigations, nor should he ever ask. And that's just not true. I mean, we would routinely brief presidents of both parties about very sensitive counterterrorism and counterintelligence investigations, because they have an Article II Commander-in-Chief authority, and there was a confluence between some of those investigations and some of those duties. But if you're talking about a public corruption case or a bank robbery or a child pornography case, no, presidents shouldn't get involved.
During the Obama era, we had a no-contact policy. So
which dates back
further. But if I wanted to talk to someone at the White House about a case, I had to file a notice, and I would call Sharon Werner and say, I want to talk to the Attorney General, the Deputy Attorney General.
Would Sharon call you back?
Right away.
Okay. Always, yeah. But she never returned I was never important enough to get Sharon to call me back.
On the other way, if I was not allowed to receive a call from the White House under the Obama policy, if they wanted to talk to me as a line U.S. attorney, they had to go through the Deputy Attorney General.
Yeah.
That's not the way it's working right now.
Yeah, so I never got a call from a member of Congress, when I was U.S. attorney, never, ever, nothing, anyone, ever. And that seemed right to me. And I didn't seek to brief the White House. The White House is a building, not a person, but I didn't seek to brief anyone in the White House about stuff I was doing. If I had a sensitive case, and we had a lot of them in the Eastern District of Virginia, because our jurisdiction includes the CIA and the Pentagon and the Norfolk Naval Shipyards and all that, I would tell the Deputy Attorney General and let her worry about it. And my view was, leave me the hell alone. You don't talk to me, I won't talk to you, and we're going to get along just fine. And if that's eroding, I worry about that.
I guess one of the points of all this is that whether they're good norms or bad norms, there's not universal agreement. I'll tell a little story about that.
There's not universal agreement on what the norms ought to be and whether they're good or bad.
Whether you can do it. Yeah. And this relates to victim contact. When we were doing the bomb threats here at the University of Pittsburgh, I reached out to Chancellor Nordenberg and said, I would like to brief you and your board as to what's going on. And I had a member of my staff report me to the FBI and say that it was improper as the U.S. attorney to be speaking to the victims. And he had a deeply held belief that was his right as a careerist at the Department of Justice, and that I was out of control.
Yeah, I can think of lots of good reasons, David, why I would turn you over to the FBI.
Let's not get into that here.
But that is not one of them. Yeah.
But there's no really universal agreement on some of these norms. Let's talk about executive orders now.
Yeah.
I mean, they're not in the news much.
Well, look, every president has done it too. So whether you love Mr. Trump or loathe Mr. Trump, this is not unique to Mr. Trump.
No, it isn't, to be sure. But the question is, have we tilted the balance between the three supposedly co-equal branches, and we really have one branch of government right now?
Well, I would say we have two. But let's put the courts aside for a minute. So I teach at the Georgetown University School of Foreign Service, and we talk about this endlessly, how Congress has completely abdicated their role in our constitutional scheme. They were designed to be slow and methodical. The presidency was designed to be, fast and active. I mean, that was a design. Whether or not it was a design flaw, I'll leave it up to you. But Congress couldn't agree that we are in the month of January if their collective lives depended on it. And so presidents for the last, I would say, at least back to FDR, have sort of, taken advantage of this. FDR, if I'm not mistaken, issued far more executive orders, but thousands more than any other president in history. Oh, of course, a lot of that was he was around for, he was president for almost 4 full terms, and World War II was raging. So there's some historical reasons, but this is not new. And as Congress continues to abdicate their role, why wouldn't a president occupy the void?
We're going to start beginning to take questions, but I think that the ending of this is where do we go from here?
Lunch.
Yeah, after that.
I think. Yeah.
We're going to pass the mic for questions, but our first question comes electronically from Peyton and Eli Manning. And it says, Jimmy Kitchen served as U.S. Attorney under Chris Christie, Chuck Rosenberg, and David Hickton. Who was the best of those three? Or was Mark Nordenberg the greatest chancellor in the history of higher education?
That's for Chuck.
What's the next question?
We have questions from the audience.
All right.
Questions?
And anything at all. I mean, it doesn't have to be on, something we just talked about. Whatever's on your mind.
Yeah. So I have 2 questions, if that's okay. The first one, I'm really uncomfortable with the idea that the president is a king. But isn't the answer to contradict Mitch McConnell that it is Congress that is supposed to be investigating the president and keeps the president kind of from being above the law because they have the right to impeach him? That's question 1.
So the answer is, yeah, I mean, structurally, absolutely, Jimmy, you're right. They have that power, but they have other powers too, including what you alluded to, the power of oversight. And the less they use that, in a meaningful way, any president, again, I think, is going to fill that void. Look, I'm not comfortable with the idea either that any president is a king or king-like. But the more you let presidents roam off leash, the more they behave in that manner.
The second question is more of an opinion. I also agree that the pardoning has gotten out of control, and it is not, I don't believe that it is being used in the way that it was designed to be used.
As an act of contrition, an act of mercy following contrition,
right.
Yes.
So just an opinion I wanted to ask you, is it time for us to amend the Constitution to change that right? Or change the way that the process works anyway?
Yeah, no. I worry. I'd rather, and this is me being, Pollyannish, I'd rather have presidents who didn't abuse the power than to try and strip it, because the way it was designed, I think, was a proper design. It's the way it's being implemented that's the problem. And maybe that's on us as voters to insist on people who will return us to some, and again, I have problems with Biden and Trump. They're of a different order. I don't mean to equate the two, because I don't think they perfectly equate. I'd rather have a president who respected that power rather than strip it from the presidency.
But
that's just my view.
Along the same lines, with regard to your first question, how is it effective if Congress can't agree that today is Friday and that they have to get 2/3 vote in the Senate? What president would fear that they're going to be impeached? And if you can't investigate a president criminally while in office, except going through the impeachment vehicle, is there no platform to investigate? Practically.
We have to elect good men and women, Jimmy. I mean, again, Pollyannish, silly, stupid, naive. I've been called worse, but I do think that's part of the answer.
I just want to pick up on the tail end of something you said a moment
Hold it closer.
when you said that you weren't equating the problems associated with the Biden pardons with the problems associated with the Trump pardons.
Yeah.
Because earlier in the conversation, as we were going from administration to administration and saying there were problems here and there were problems there, I was getting the sense that they were being equated.
Yeah,
what is it
they're
that
not.
makes the Trump pardons different?
So to be clear, when I talked about George H.W. Bush, it was the folks involved in Iran-Contra, if memory serves. With Bill Clinton, it was his brother Roger, and then a financier and campaign donor named Mark Rich, which they kind of slid through at the last second of his presidency. With Biden, it was not just the fact that he promised not to pardon his son, but that when he did, he denigrated the Department of Justice and said his son had been selectively prosecuted. A term of art for us as prosecutors, which had been litigated and which Hunter Biden had lost in the courts of the United States at least twice, I think. And so for a sitting president to denigrate, and Biden's not alone in this, the United States Department of Justice, Mark, really rankled me. I want to be clear. I think what Mr. Trump did is of a different magnitude, right? Again, if you believe that pardons are for people who serve their time, pay the penalty, if you will, right? Are contrite, are remorseful, apologize, reimburse victims, live a good life, demonstrate good deeds, and then seek mercy. It's hard for me to understand how 1,600 people who, tried to overturn a fair and free election would merit that sort of consideration. And even, some large number of those were disorderly conduct, property damage, and obviously not as serious as what 400 of them did, assaulting police officers. So even if you want to take 1,200 off the table, for the life of me, I can't understand how 400 people who assaulted police officers and members of the media deserve a pardon. I try not to be hyperbolic. It's incomprehensible. So lots of bad pardons by lots of presidents of both parties. But this is, I think, of an order, at least to me, an order of magnitude different.
I just wanted to know, what do you see as the future of the Supreme Court?
The future? Well, for one thing, I hope it remains 9. And I'm not being facetious. The number of justices on the Supreme Court is not set by the Constitution. It's set by Congress. And the number has varied over the years. I think it's been as high as 11, as low as 5. Right now it's 9. And people have talked, when Biden was president, let's make it 13 and take back the majority. That's stupid, to use a technical legal word. Because then the next folks make it 17, and the next folks make it 23, and then they make it, 37. And so I think the future is 9, I hope. But they are losing the confidence of the American people. And that is deeply dangerous. Because if you think about it, the Supreme Court has 0 enforcement power. No federal judge has enforcement power. They can issue orders all they want, but they need another branch of government to carry them out. And so, if you really want to think about a parade of horribles, it's when people start ignoring the orders of federal and state judges. And, there's that, I think, apocryphal, was it Andrew Jackson who said that about, is it Jackson who said that about Chief Justice Marshall? And it may be apocryphal, but it's something along the lines of, it's his order, let him enforce it. And it's not to get overly nerdy again, it's part of the legacy of Marbury versus Madison, the seminal 1803 Supreme Court case, in which Chief Justice Marshall was very careful to assert that it's the province and duty of the Supreme Court to say what the law is, and then required President Jefferson to do absolutely nothing. because he worried that Jefferson would simply ignore him. So, this is tenuous. This is a long-term problem if faith in the courts continue to erode. By the way, the courts are not unique. Faith in academia is eroding. Faith in the media. Faith in big business. I mean, you name it. Faith in Congress. Although I think Congress's approval rating is now technically an asterisk. But this is not unique to the courts. If the trend continues, the future is dark.
Question relates to, I guess, access to the press, which I think in today's times is very important. Trump's first administration pushed back on allowing access, or at least free and open access to the press, at least in news conferences, and it appears that he may be considering the same in this administration. Is there anything legally that the press can do to push back against such a move?
It's a very good question. I have a kind of a simplistic answer. They can publish. I mean, so Mr. Trump was not the first president who pulled some journalist's press pass, right? And journalists don't get to go to the White House or the Department of Justice or the Pentagon because they feel like it. They're granted a press pass controlled by the executive branch. So, can a president make life a little more difficult or a little bit more miserable for a journalist? Yeah, sure. But the First Amendment law on prior restraint and on the rights to publish are, and again, you're a new dean here. By the way, who in the world would celebrate their 8th day as dean by coming to listen to me talk? I mean, these are as strong constitutional protections as we have. So I'm not actually worried about that. The prior restraint stuff and the right to publish, the right to assemble, the right to speak. I mean, none of it is, there are some limitations on all of that, but it's incredibly robust. So when I think about the things that keep me up at night, that's not one of them. Is that Brenda?
Yes.
I met Brenda right before the thing started. She just retired from the Pittsburgh Police Department.
Thank you.
Right? Thank you for your service.
Thank you. My question and concern is about security clearances.
Yes.
Can you help us understand
Unlikely.
where is that going?
Yeah.
And how dangerous that is?
So the entire national security apparatus of the United States is vested in the president. There are 17 intelligence agencies in the United States, from very, very big, CIA, NSA, to very, very small, Coast Guard, DEA, but there are 17 of them. Every one of them is a part of the executive branch. And so all the apparatus, including security clearances, the processes for security clearance, the designations, top secret SCI, secret compartmented information, secret, all that stuff, all flow from the authority of a president. So, if you want to worry about something, any president can corrupt that, turn that to his or her own needs. You want to take a security clearance away from me, Brenda? You're the president? There's not a damn thing I can do to stop you. You want to grant me one, even though I'm not qualified. That's all your call. Now, again, to the extent that the media does its job and calls this out, and Congress does its job and oversees it, there can be some pushback. But let me be clear, that is wholly within the province and authority of a president. Granting, revoking, classifying, declassifying, all belongs to the president.
I want to follow up on the question about press, but in a little bit different way, and it relates to security clearances and what you said, because we've heard the term retribution a lot recently. And one could surmise that those who say they're going to engage in retribution then create fear in others. And whether those others are in another branch of government or otherwise. What is the role of fear in the process of government, and how does that relate to your initial comments about having a culture of rule of law?
Right, so I guess what you're getting at is that if people are fearful, right, they're not going to do their duty in the way they would normally do it. They may leave government service. Look, I hope this doesn't come across as Pollyannish. I think in many of the most important departments within the executive branch, the political layer is by design very, very thin. That's not an accident. I mean, in other words, it's not a bug. It's an attribute. Folks here, some will know, I know we have some folks here retired from the FBI. How many people work at the FBI? It's about 37,000. About a third are special agents, give or take. How many of them are political? Of the 37,000 employees at the FBI, how many are political? And the answer is 1. That's a good thing, not a bad thing. And so, you know, my hope, my belief is that, yeah, folks may be a little fearful, concerned, worried, anxious about a new administration. And by the way, this happens with every new administration. It may be happening more now, but it happens all the time. I've lived through a number of these transitions. Career folks usually do the right thing in the right way, not perfectly. I mean, David mentioned a career person in his office with whom he apparently had crossed swords. But this is a strength, and I think this was what gets us through. I really do.
Let me pick up on what Dave said at the beginning of their segment. Thank you all for being here. And can you all join me in thanking Chuck and Dave for a terrific program?
Thank you, sir. Good conversation.